26th Annual HNBA Uvaldo Herrera Moot Court Competition. I am Judge Castro, and I'm from Minnesota, and I'm the co-chair of the HNBA Judicial Division, and I, along with my co-chair and the director of this competition, Judge Betty Capote Urban, who's from Florida, welcome you to what undoubtedly is going to be an exciting battle. Before I turn this proceeding over to the bailiff, I want to inform everyone that at the completion of the arguments, the judges will provide feedback upon completion, and you will be asked, upon completion of the feedback, that is, you'll be asked to leave the webinar to allow the judges an opportunity to submit their score sheets. The award ceremony will be at 4 p.m. Eastern Time, and you are all welcome to attend, and you should be able to obtain that link through the HNBA webpage. Today, we are honored to have a distinguished panel of judges. From the Supreme Court of Texas, we have Justice Eva Guzman. From the Supreme Court of Minnesota, we have Justice Ann McKee. And serving as our Chief Justice here today, we have Judge Jimmy Virreina from the United States Court of Appeals for the Federal Circuit. Thank you, judges, and good luck, participants. I now turn it over to the bailiff.
The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon. We have one case scheduled on our docket for today's argument. This is number 21-001, Isabel Flores, petitioner, versus Michelle Leon and David Jameson, respondents. We've received all the briefs and papers filed in the case, and we're ready for oral argument. Is petitioner, counsel petitioner, are you ready to proceed?
Yes, Your Honor.
Okay. And how much time have you reserved for rebuttal?
2 minutes, Your Honor.
Okay. I ask that all litigants state your name clearly at the beginning of your argument. And Ms. Deaver, Counsel Deaver, you may begin now.
Juanita Deaver, the first speaker on behalf of the petitioners, Your Honor. May it please the court. My name is Juanita Deaver, and I, along with my co-counsel, Mr. Robert Torres, represent the petitioner in this case, Ms. Isabel Flores. Mr. Torres will address the admissibility of Ms. Flores' excessive force claim under the Heck Doctrine, while I discuss the Fourth Amendment. At this time, petitioners respectfully request 2 minutes for rebuttal. The 12th Circuit Court of Appeals held that Ms. Flores was not seized under the Fourth Amendment. This court should reverse this decision for 2 reasons. First, Ms. Flores was seized under the Fourth Amendment. And second, the officer's conduct was unreasonable in light of these circumstances.
Counsel, what do you mean when you say that, when you use the word seized? Are you referring to the person to actually getting shot?
Yes, Your Honor. The moment the bullets entered Ms. Flores' body, she was seized in that moment under the common law.
The way I understand it is that she escaped. She escaped for a whole day. How can that be seizure?
It's a seizure under the common law, Your Honor, because based on the common law definition as laid out by the framers understood the seizure of a person to be a common law arrest, a term used synonymously with seizure, which occurred when an officer applied physical force to restrain someone, regardless of whether the individual submitted. Per this court,
Ms. Deaver, doesn't that physical force, though, require that the freedom to move is restrained? And that's really one of the difficulties here. If you look at U.S. versus Mendenhall, it refers to freedom of movement being restrained, and that wasn't the case here. So how can that be even a common law seizure?
Because, Your Honor, it applies. Because at the common law, seizures could be effected in 2 ways: by an officer's show of authority that caused the individual to submit, or by an application of physical force with the intent to restrain. And these definitions are perpetuated by this court in Brower and Hodari D, and even by the 10th Circuit in Brooks versus Genzel.
Counsel, if we see it more as an attempted seizure, are individuals free from an attempted seizure?
No, Your Honor, individuals are not free under an attempted seizure. And specifically, this is because a 1983 claim requires that an individual first show that a seizure has occurred, and second, that the seizure was unreasonable.
And so if we disagree with you and we find it to be an attempted seizure, you lose on issue 1. Would you agree?
Yes, Your Honor. However, there is still a protection against excessive force from officers. And in Hodari D, this court discussed that seizures in the context of the common law and concluded that the application of a restraining physical force, even when unsuccessful, still constituted a Fourth Amendment seizure. So
the facts of Hodari are a little bit different since you brought that up. The ultimate holding of that case was that the fleeing suspect who discarded the drugs while in flight was not arrested until he was tackled. And so why isn't there a good argument that mere touching, whether it's a bullet or an officer somehow touching a suspect, is not a seizure?
Because in the court, it's not good policy, Your Honor, because under the court's definition, it's the intent to restrain. And it's to create, the purpose of 1983 was that there is to establish a seizure has occurred and that it was unreasonable. It's not just mere contact between an officer and a civilian.
Can an individual be seized by an inanimate object, such as the bullet here?
Yes, Your Honor. Individuals can be seized by bullets, and lower courts have held that being shot with a taser, being shot with pepper bullets constitutes an intrusion.
How about being seized by a word like halt?
Yes, Your Honor. Individuals can be seized by words alone under the common law, that show of authority. If an officer tells an individual to stop and that individual stops, the individual is seized under the meaning of the Fourth Amendment. But that does not mean it gives rise to a seizure that requires a 1983 claim, because again, once this court establishes that an individual was seized, then it evaluates the reasonableness of that seizure. So when respondents shot at Ms. Flores, intending to stop her from leaving, and their bullets entered her body, she was in that exact moment seized under the Fourth Amendment. And as this court explained in Hodari D, seizure means an application of physical force to restrain, move, and even.
At what point does a seizure happen? When you pull the trigger, when the bullet exits the gun, when the bullet hits the individual, or when the policeman decides to even pull the trigger? Where does a seizure happen?
When the bullets enter the individual's body, Your Honor. This court in United States versus Castleman addressed that bullets constitute an intrusion of force. And the analogy that was used is that the pulling of a trigger is an indirect force, but constitutes actual force once the bullets strike the individual. So
I want to be clear, what rule of law are you asking us to rule on here? What's the rule of law?
Ms. Flores isn't asking this court to create a new seizure definition, but to uphold its precedent with regards to the common law definition that has been perpetuated by this court. And as discussed by Justice Scalia, that even though Justice Scalia's definition, when he laid out that even an unsuccessful attempt can constitute a seizure while dicta, is significant here because it's about the level of intrusiveness that's being protected, in addition to the protection of freedom from governmental restraint. So surely it should apply to bullets that enter an individual's body.
So is the common law or the historical and ordinary meaning of seizure is taking possession of a criminal suspect. So you have a point here where I think I understand your view to be the minute the bullet enters the suspect's body, a seizure has occurred, they've taken possession. But what I'm struggling with is that's only temporary. So there's just this temporal component because the suspect is able to leave and flee for a day. So how do you reconcile the historical meaning with the rule you're articulating?
The framers understood seizures to be a protection of an individual's freedom against excessive force from officers. So these definitions were perpetuated in such a manner that there must be governmental intent to stop the individual's movement. And then regardless of the success, even if just for a brief moment, that is a seizure. But it is significant because it does not give rise to every seizure from an officer constituting a 1983 claim. There is this second prong of reasonableness that the courts address. And that takes me to my second point, that in these circumstances, Officer Jameson and Leon's conduct was unreasonable in light of these circumstances. The Fourth Amendment guarantees protections against unreasonable seizures, and courts analyze these questions of reasonableness objectively by considering all the facts and circumstances surrounding the situation, as noted by this court in Graham versus Connor. What is reasonable depends on all the circumstances surrounding the seizure and the seizure itself, as noted by this court in United States versus Montoya de Hernandez.
Do we look at reasonableness with respect to the attempts that they made to stop her from fleeing? And so an officer fires the weapon and the suspect is still free to leave. Does that make the use of the weapon unreasonable since she was able to get away?
It was unreasonable, Your Honor, because taking into consideration the circumstances faced by these officers, Ms. Flores was not the subject of the warrant being executed that night, as reflected on page 1 of the record. She was afraid she was being attacked by carjackers. Officers Jameson and Leon failed to identify themselves as officers, as reflected on pages 1 and 2 of the record. It was the early hours of the morning. There's a factual dispute in the record on page 2 as to whether Ms. Flores' vehicle moved 1 or 2 inches or charged at the officers on a rampage, as the respondents contend.
But also, the police were dressed in their tactical gear, is that correct? Does the record reflect that?
Yes, Your Honor, it does.
And so perhaps if they didn't identify themselves, what role, or how does that play into our analysis since they were in their full tactical gear?
It just gives rise to the circumstances surrounding the seizure itself, Your Honor. And again, this is an individual that was shot at 13 times and struck twice despite already driving away. It's not disputed in the record that she was shot in the back, as reflected on pages 1 through 3 of the record. Ms. Flores.
What if they had missed her and let's say the bullet, whizzed by her hair but it didn't actually hit her? How would that play into the analysis given your rule of law that you're asking us to decide on?
There are 2 minutes remaining.
If the officers had missed, she would not have been seized, because although it was an attempted force to stop her, it did not strike her and it did not prevent any type of movement.
Well, help me follow your argument, because I just heard you argue that it was the intent, that we should focus on the intent. And so I'm not following exactly.
The rule is that it is a physical force with the intent to restrain, regardless of whether or not it is successful. Under the common law, in the terms used by the framers, meaning if the bullet had entered her body and she kept going, it was a force that struck her with the intent to stop her. If the bullet shoots past her, she's not seized and then cannot give rise to a 1983 claim by saying that it's.
But you still have the intent there. I mean, it's just the difference is that one officer is a good shot and the other one is a bad shot, because both officers intend for the bullet to strike.
It's an intent for the bullet to strike, but it's unsuccessful in that it does not strike the individual, Your Honors. This isn't an expansion of the common law, but just to uphold. And in fact, this court can narrow the common law definition today by just narrowing it to the use of deadly force, not even any form of contact between.
All right, I think you're into your rebuttal time. Do my colleagues have any other questions to ask? Okay, Counselor, we'll restore you back to your original 2 minutes of rebuttal time. Let's hear from the other side now.
May it please the court. My name is Robert Torres, and I also represent the petitioner in this case, Ms. Flores. The lower court mistakenly held that Ms. Flores' Section 1983 claim is barred by this court's holding in Heck versus Humphrey. This court should reverse the lower court's decision for two reasons. First, Ms. Flores' Section 1983 claim does not imply the invalidity of her underlying criminal conviction. And second, Ms. Flores' plea of no contest is not subject to Heck analysis. Ms. Flores was in a parking lot when officers fired 13 shots at her, 2 of which struck her in the back and left her partially paralyzed. This is reflected on page 2 of the record. Ms. Flores subsequently pled no contest to aggravated fleeing against Officer Jameson, and the lower court subsequently held that her civil claim was barred by this court's holding in Heck versus Humphrey. Which brings me to my first point, that Ms. Flores' Section 1983 claim does not imply the invalidity of her underlying criminal conviction. In Heck versus Humphrey, this court held that when an individual's theory for relief in a civil claim necessarily negates one of the essential elements of her underlying criminal conviction, then there will be a preclusive effect that prevents the individual from bringing the civil claim. However, this court was careful to stress the language necessary.
In this case, your client actually pled to fleeing, to aggravated fleeing, and now you're standing before the court and you're arguing for us to just simply overlook that.
No, Your Honor. Petitioners do not contend that the conviction should be overlooked. Rather, the conviction is valid. It was valid for the purposes of punishment. However, Ms. Flores can still maintain an excessive force claim even though she committed the offense of aggravated fleeing.
But
And
counsel, how is that not irreconcilable? Because you have granted it was no contest. I mean, the fact that it was a no contest, how does that play into your analysis compared to if it was fully litigated or if she had in fact pled guilty?
Yes, Your Honor, it factors into the analysis that it was a no-low plea in the sense that courts have held that whenever a no-low plea is entered, the underlying facts cannot be used against that individual in the subsequent civil claim. And that's been held by United States versus Willis in the 11th Circuit, as well as Clenn versus City of Loveland in the 10th Circuit. And United States versus Willis made clear that a no-low plea does not mean I confess, it means I do not contest. And because Ms. Flores did enter into a no-low contest plea, her conviction rested on entering the plea. And that's shown on page 12 through 13 of the record, that her indictment merely states Ms. Flores entered into a no-low, or Ms. Flores was charged with aggravated fleeing on or about the 21st of June. And her criminal conviction merely states Ms. Flores pled no contest to the charges. And there was no factual determination that had to be made. There's a precedent that because the no-low plea only, essentially it pulls itself up from its own bootstraps in the sense that the evidence to convict is merely the plea of no contest itself. And I would also urge this court to look to the 9th Circuit case of Lockett versus Erickson, where in a similar situation, an individual pled no contest after a warrantless entry into their home occurred. And they brought a subsequent Section 1983 claim, but the 9th Circuit reasoned there that the conviction did not depend on the legality of the search or the legality of the warrantless entry. That was not, there was no verdict reached on that. And so that it did not raise the same issue that normally collateral issues might in other subsequent civil cases. Because
counsel, help me out here, because even with the no contest, the court obviously found the facts to be proven in order to enter the conviction. Obviously, if they had found or if they had agreed that the facts didn't support a conviction, she would have no record. So the fact that she didn't say it, help me out how there still is some factual findings that seems to me would be relevant to the analysis here.
Well, Your Honor, yes, Your Honor, that's not on the record though. The only thing we have on the record is on page 12 through 13 that her indictment merely states that she was charged with the aggravated fleeing offense, and that she pled no contest. But the crux of the issue is that none of that, for purposes of the conviction, it's final and valid. And she did in fact serve 2 years in prison, but there was no, the conviction did not depend on whether or not excessive force was used. That was not litigated at that stage. And simply pleading no contest does not allow that to be adjudicated as final for the purpose of her Section 1983 claim.
Why is the vehicle by which the conviction is obtained sort of the crux of your argument? Regardless of the vehicle, she was convicted, and don't we have this inconsistency then when you're asserting this claim?
Yes, Your Honor. For purposes of the conviction, it is final and valid. However, even if the conviction is final, the Heck bar should still not apply because there is not an inconsistency between the underlying criminal case's elements and Ms. Flores' Section 1983 claim. And the reason for that, we know this is because the Sixth Circuit in Schreiber versus Moe, the Seventh Circuit in Van Gilder versus Baker, and even the 10th Circuit, which the lower court heavily relied on in Havens versus Johnson, have all concluded that excessive force claims are generally not mutually exclusive to a subsequent criminal conviction, even where individuals pled guilty. And
so in other words, counsel, the Heck doctrine would never apply absent a guilty plea or the issue being fully litigated.
Your Honor, the Heck doctrine would apply if the theory for relief necessarily invalidates what was found in the criminal case. And a way that this could happen in Ms. Flores' case is if the statute, which is on page 8 of the record, stated that a lack of excessive force was an essential element of the criminal statute. That's not present on the statute, which means that there is no necessary clash that this court held needs to exist in Heck versus Humphrey. Or if it made excessive force an affirmative defense, then that would have been something that she would have impliedly chose not to contest, and then the Heck bar would apply. But those aren't the facts in the case at bar. And additionally, Ms. Flores is shot in the back, which means it is undisputed that the shots entered her back, which means that it is possible, it is not mutually exclusive for her version of the facts alleged in the complaint, that she drove away and officers engaged in excessive force after the offense had been committed. That is, it was not reasonable for officers to fire 13 times at her in a public street as she was attempting to flee, and 2 of which ended up leaving her partially paralyzed. And we know that this excessive force, for the other circuits that have found that the excessive force can still occur even though a criminal offense has occurred. We also know that under the 10th Circuit's Havens versus Johnson case, that there presents a factual scenario that's similar to Ms. Flores's, where an individual was in a vehicle and drove at officers, and officers shot at the individual and stopped the vehicle. That individual subsequently brought a Section 1983 claim and attempted to argue that the vehicle moved forward on its own. But Ms. Flores does not allege that. Ms. Flores has a temporal distinction.
Don't we have evidence?
There are 2 minutes remaining.
Don't we have evidence in the record that shows that Ms. Flores moved the vehicle while the officers were close by or were placed in danger?
Yes, Your Honor. And it was at that point that she committed the aggravated fleeing offense. However, that once the danger dissipated and she drives away, the officers can still engage in excessive force by firing at Ms. Flores as she runs away. And at the very least, because this is a summary judgment action, Ms. Flores has met her burden of proving that there is a genuine issue of material fact. And at the very least, she is owed a jury trial to determine whether or not it was reasonable for officers to engage in that use of force when they fired at her as she attempted to flee. And that's something that a jury should hear and determine and not be precluded by the Heck versus Humphrey doctrine. This is also simply better policy.
Why isn't the evidence of her driving away at a high rate of speed from officers who are wearing their full tactical gear Why isn't that enough here?
Your Honor, that is enough to find for aggravated fleeing, but it's not enough to preclude her excessive force claim or to adjudicate it as final that the use of excessive force was okay. And I would urge this court to look to the statute because the lower court heavily relied on.
Enough to bar her civil claim, right?
Yes. I'm sorry?
It's enough to bar her civil claim.
No, it's not enough to, no, Your Honor, it's not enough to bar her civil claim because there is a temporal distinction, because there is a difference in time from when the offenses take place. And her knowledge of whether or not they were officers is not critical to the criminal statute. And we ask that this court reverse and remand.
The time reserved has expired.
Okay, let's hear from the other side now.
Good afternoon, Your Honors. Mr. Chief Justice, and may it please the court. My name is Carla Martinez, and I, along with my co-counsel Viridiana Ordonez, represent officers David Jameson and Michelle Leon. I will address why petitioner was not seized under the Fourth Amendment, and my co-counsel will address why her claim is barred by the Heck Doctrine. The goals of liberty and safety mandated by the Constitution are in tension today, but they can coexist. Accordingly, respondents respectfully request that this court affirm the decision of the 12th Circuit for two reasons. First, under existing case law, petitioner failed to show that she was seized because the officers did not successfully acquire custody or control of her person. Second, the 12th Circuit applied Fourth Amendment principles that represent long-standing Supreme Court precedent and protect public safety. Turning to my first point. From the time of the founding to the present, the word seizure under the Webster and legal dictionaries has meant taking possession, which means actually bringing a subject within physical control. The Supreme Court first stated in Terry versus Ohio that it can only conclude that there has been a seizure within the Fourth Amendment when an officer, by means of physical force or show of authority, has restrained the liberty of a citizen.
How long must a person be under seizure in order to meet your definition of that? If an officer brings somebody under control by shooting them in the leg and the person limps away and they capture him later that day, or say that they get shot in the arm and the person's never caught, does that make a difference?
Well, no, Your Honor, because the end result is always the same, regardless of whether it was through a show of authority or through the use of physical force. At the end of the day, the person has submitted to the officer's custody or control, which is when they are seized and they are entitled to bring a Fourth Amendment challenge. And as this court in the past 40 years.
Although, are you saying that they have to have stopped? So for example, here, the fact that she fled, that's what makes this, that this is not a seizure? Is that what I hear you saying?
Yes, Your Honor, that is correct, because she
is that consistent with Hodari?
It is, Your Honor, because in Hodari, the court actually explained that the Hodari had not been seized because he did not submit to the show of authority. And additionally, while the facts are not exactly analogous to what happened here, the court held there that he was seized when the officers actually tackled him. And I would like to point out that the petitioners err in relying on Hodari and the common law, because under the common law, officers were actually allowed to use whatever force was necessary to arrest a fleeing individual. Further, in Hodari, this court stated that the common law does not make an attempted seizure a seizure, and such attempts are beyond the Fourth Amendment scope. Hodari.
What makes it, counsel, what makes a seizure an attempted seizure? Because what you have here is a situation where Ms. Flores was at least temporarily seized. She, at least temporarily, was stopped from her activity because of the gunfire. So how is that an attempted seizure when it seems to me a seizure actually occurred, even though it was temporary?
Your Honor, and a temporary seizure is not a seizure, or because one cannot be seized and then unseized. And Justice Scalia actually explained in Hodari that there are also no continuing seizures. One cannot claim to be seized and then continue to be free.
But let me ask you, so a police officer temporarily seizes a suspect and beats them and uses excessive force, and there's a really valid claim, but the suspect is pretty strong and gets away, no seizure?
No, Your Honor, in that case, it would be a seizure because the individual was in the control and custody of the officers. And that is not what happened here. Here, Ms. Flores continued to flee. She was never stopped or restrained, or her liberty was never also in the control of the officers, because as the record indicates on page 2, she not only continued to drive away for 70 miles, but she also hit other vehicles and she managed to steal another vehicle from an innocent victim. How can one say they were seized and claim that their liberty was restrained while at the same time simultaneously doing all of those things?
What's the legal distinction, though, between being temporarily seized because of another form of physical intrusion, not a bullet? I'm not seeing that, because in my hypothetical, the suspects still got away in the first instance. So they got into a scuffle with the police officer. The police officer used a taser and all sorts of other things. And then in here, the police officer used a bullet, temporary restraint, and then she got away. Is there a difference?
There is a difference, Your Honor, because the officers never were in contact with her, and they also never restrained her freedom of movement. And Supreme Court precedent tells us that restraint of a person's freedom of movement is central to whether a seizure has occurred. Petitioner failed to show that she was seized.
How is it not? They approached the vehicle, they were within inches of the vehicle, they're in their tactical gear. How is that not showing their use of force? I mean, it seems to me that that's sort of incompatible with what you were just arguing.
Your Honor, there was no use of force when the officers approached the vehicle. The record indicates on page 1 that the officers were there to arrest an individual involved in a crime trafficking ring. So they decided to make contact with Ms. Flores and another individual because they were immediately outside of the residence of the individual. And upon them approaching the vehicle is when the individual started to run away, and Ms. Flores got into her car, put her car in drive, and almost ran the officers over. So there was no show of authority. And also petitioners are arguing that she was seized the moment that the bullet struck her body. But here, submission is essential. And to determine if there was submission, the 10th Circuit in Brooks versus Gaensla looked at the totality of the circumstances, because it depends on what the person was doing before the show of authority or the use of force. A fleeing suspect is not seized until he is fleeing physically overpowered or restrained. But one person sitting in a chair may submit to the use of authority by not getting up to run away.
Ms. Martinez, what is the harm against which the Fourth Amendment protects?
The Fourth Amendment protects people from unreasonable searches and seizures, Your Honor.
So it's been described as interference with personal security in the Terry opinion out of this court. Why aren't shots fired into the body fundamentally an interference with one's personal security?
It is not, Your Honor, because she was never detained or submitted to the officer's custody or control. They were never able to arrest her until a full day later. So she was able to flee from the police custody for over 24 hours. And as this court illustrated in Hadari, a ship that is still fleeing, even though it is under attack, would not be considered to have been seized as a war prize. We cannot say that Ms. Flores here was seized when she continued to evade police. She put the public safety in danger, and she still managed to check herself into a hospital under a different name. So one who has—
Can we say that there was interference with her personal security or no? Here, in this case.
No, Your Honor, because the officers only reacted in self-defense and she continued to drive away. Her personal security and her freedom of movement was never restrained. And
Counsel, the fact that she was partially blinded and paralyzed, does that play into the analysis at all? And if so, why?
That was an unfortunate result of the circumstances that arose here. But the point is that she was never seized, and that is why she is barred from bringing an excessive force claim under Section 1983, because there must be a clear constitutional violation, and there was none here. A clear test, Your Honors, is also necessary to tell when a seizure occurs and when it does not. This is helpful for officers, for the public, and for our judicial administration. You are seized if you are detained or in the custody or control of officers, whether it's through a show of authority or physical force, or you are not if you escape. And that is why respondents are requesting that this court affirm the decision of the 12th Circuit. And turning to my second point, the 12th Circuit properly adopted a rule based on this court's holding in Broward versus County of Inyo. In Broward, this court said that a Fourth Amendment seizure took place because a roadblock placed by police terminated Broward's movement through means intentionally applied. The plain meaning of the word seizure and various Supreme Court interpretations indicate that the government must do something that gives it the opportunity to control the suspect's ability to evade capture or control. Here, the officers did not terminate petitioner's movement or acquire physical control of her person. Therefore,
Your opponents would argue at this point that what matters is the intent of the officers, that the officers intended to seize her when they shot. What's your response to that?
Your Honor, it cannot be only based on the intent. There must be a result. If the officers intend to arrest someone or to seize someone, then there would be seizures everywhere anytime that they try to even make a simple investigation to ask someone, because if they intended to.
That you're arguing is that a person has to probably be killed in order for there to be a seizure under these type of circumstances.
No, Your Honor, we are not stating that. The respondents are saying that if a person if the suspect ends in the custody or control of the government over the officers, whether it's through a show of authority or through the use of force, then they have been seized and they are entitled to their Fourth Amendment rights. And that is what this court has said in Hadari, in Brower, in Brenlin, and even the common law on which the petitioner relies upon.
There are 2 minutes remaining.
In the old case, common law case, Whitehead versus Keys, the judge there instructed the jury, telling them that they had to consider whether the sheriff there had actually stopped the individual, and that if he had not actually used enough force to actually arrest him, then the
My colleague Justice Guzman was asking about the Terry case, and it sounds to me right now that the Terry case does not help you. That if a person is for example shot, or you use the example of a ship being fired upon. The ship is fired upon, and one ship chases the other for a period of time, and causes some sort of damage to the fleeing ship. Under your view, the fleeing ship is never under a personal attack, or their personal security is never in danger. Is that correct?
Well, not exactly, Your Honor, because Terry versus Ohio actually does help us because it was the first case where this court illustrated that a person can only be seized if their freedom of movement or their liberty has been restrained. Then this court expanded upon that in Brower, in Hadari, and in Mendenhall to analyze the totality of the circumstances or other things that happened during the course of the events. But the end result was always the same.
Does it equate a seizure with personal security or endangering the personal security of another?
Your Honor, that could be part of it, but it is not the end result.
I mean, that's what Terry holds, right?
No, Your Honor. In Terry versus Ohio, the holding was actually different on whether a person can be stopped under reasonable suspicion. But the court
The time reserved has expired.
You may answer the question.
In Terry versus Ohio, the facts were not analogous to here, but the court did explain on footnote 16, which hasn't been referenced by other cases like Mendenhall, that a person's liberty of freedom or movement must be restrained in order for this court to make it a seizure. And as to your question about the ship, Your Honor, a ship would not be seized if the shots fired at the ship did not actually stop it, and the persons or the other ship actually didn't take control of the other ship. And here, Ms. Flores evaded police for 24 hours and was never under the custody or control of the officers. That is why there was no seizure under the Fourth Amendment here. Thank you.
Okay, do my colleagues have any other questions for Councilor Martinez? Okay, let's hear from Councilor Ordonez, please.
Good afternoon, Your Honors. Mr. Chief Justice, and may it please the court. My name is Viridiana Ordonez, and I represent respondents Michelle Leon and David Jameson. Two judicial decisions that contradict each other threaten the credibility of our legal system when allegations of a civil claim under Section 1983 have the potential of invalidating a conviction without first following proper procedure. This court should affirm the decision of the 12th Circuit Court of Appeals for the following reasons. First, the Heck Doctrine bars petitioner's Section 1983 claim for damages because her allegations under her civil suit are contradictory to her conviction and imply that that conviction has been invalidated. And second, the type of plea entered does not determine whether a claim under Section 1983 is barred under the Heck Doctrine. Turning to my first point. A Section 1983 claim is a civil rights lawsuit that can be filed by a person whose civil rights have been violated by a person acting under color of law. But as my co-counsel pointed out, petitioner was not seized. And without a seizure, there can be no civil rights violation under the Fourth Amendment.
In the case of Terry, we held that interference with personal security is a harm against which the Fourth Amendment protects. You're aware of that case, correct? How does that play into your argument?
Well, Your Honor, as my co-counsel stated, it is really about whether the person has been taken in the police officer's custody or the physical control has been restrained.
That's not what Terry says. Terry says interference with personal security. If you shoot somebody in the back and then they escape for 3 hours, or if you follow a ship and you're firing at the ship and the ship is seeking to escape, isn't that interference with personal security?
Perhaps, Your Honor, but this is about her conviction under the Heck Doctrine. And here, it is about the allegations to her current conviction for aggravated fleeing. And even if this court were to find that petitioner was seized, this court has held in Heck versus Humphrey that if new allegations under Section 1983 are brought forward, but those new allegations imply that a criminal conviction has been invalidated, then it is barred under the Heck Doctrine, and the Section 1983 claim cannot proceed.
Ms. Ordonez, is it possible for the claims to coexist? I'm thinking about a situation where you get arrested for shoplifting and you clearly took items that weren't there, but you also were the victim of excessive force. And so why couldn't you maintain a 1983 claim? I don't see the inconsistency in that scenario. Is this so different from that?
Your Honor, in your scenario, there is no inconsistency, and this court only bars the Section 1983 claims if they conflict with the criminal conviction. And in your hypothetical, it does not, but in this case, it does. And a civil suit under Section 1983 can imply the invalidation of a conviction when it denies essential elements of a conviction that are needed for that specific charge. For instance, in Havens versus Johnson, a decision out of the 10th Circuit, Havens was convicted of attempted first-degree assault, a charge that requires intent after he tried running over police officers with his vehicle. But in his 1983 claim, he changed his allegations to say that the car had moved forward on its own, and he never meant to run over the police officers.
Counsel, here there really wasn't any litigation of the underlying criminal matter, right? I mean, there was a no contest. So Ms. Flores really didn't admit to anything. So tell me why that doesn't matter.
Well, Your Honor, the Heck Doctrine is really concerned with the conviction and with the new allegations. And a no contest plea in the end ends in a conviction. And the conviction that petitioner has at this moment is currently valid. And the fact that the person did not stipulate to the facts of the case or admit any guilt is not really relevant because currently her conviction still stands and her new allegations under her civil suit are contradictory to that conviction. And here, petitioner's claims are also barred because they contradict her aggravated fleeing conviction. And an aggravated fleeing conviction, as stated on page 8 of the record, has several elements, but only 2 are central to this dispute. And that is petitioner's willful and careless driving of a vehicle after a police officer has given her a visible and an audible sign for her to stop. And the criminal court found that these elements were necessarily met before convicting her. Petitioner was willful and careless in her driving when she moved towards the officers, endangering their lives. The officers were in uniform because, as stated on page 2 of the record, they were wearing tactical vests with police markings that clearly identified them as law enforcement. And the officers—
does the record support your opposing counsel's opinion or position that they did not announce themselves? Yes, they had the tactical gear on, but did they announce themselves?
Your Honor, the record is not clear on that, but they were wearing tactical gear with police markings that clearly identify them as law enforcement. And initially, they just approached her to ask her for her name and to identify herself in order to confirm whether or not she was the subject of their arrest. They also asked her to put her hands up, and she started making furtive movements inside the vehicle. And then they were forced to brandish their weapons in an effort to protect their lives because they were attempting to avoid being crushed by her vehicle.
Ms. Ordonez, under the facts as you've just described on this record, is it at least plausible that the officers engaged in excessive force after her aggravated fleeing offense was complete? So I'm seeing kind of a timeline here, and it seems to me like you had the offense of aggravated fleeing, and then they engaged in the conduct which gave rise to the paralysis and the blindness.
Your Honor,
can we parse it out that way?
Your Honor, all the events were linked in this case because the aggravated fleeing conviction also has another element that requires the endangerment of the life of another person. And in this case, well, you are right, Your Honor, in that the vehicle moved forward and that's where the crime started, and the police officers were in danger then. But then the vehicle also moved away and her driving was erratic. She drove over a curve, over landscaping, and then later on hit another vehicle and then took another person's car. And those are all signs that she was putting other people's lives in danger. Furthermore, her new allegations under her civil suit contradict her criminal conviction because the willful and the careless aspects of her conviction require an actual awareness of the risk created. And if now she's claiming that she did not know that the police officers were law enforcement, she's denying the willful and the careless elements because she could not have fled from police officers if she never thought that she was running away from them. And then at that point, she could not have been willful and careless after receiving a sign that she says she never received. And the willful and the careless elements are essential. The criminal court determined that these elements were met by her present actions, and that is why she was convicted for that charge. And those charges stand true today. She cannot have an aggravated fleeing conviction and at the same time claim she wasn't fleeing from the officers because that would be inconsistent. And that is exactly what the Heck Doctrine is attempting to avoid, inconsistent rulings. And again, the no contest plea is not relevant under Heck because at the end of—
It would seem that anytime there is a companion criminal matter, whether it's resolved via no contest or an Alford plea or a plea of guilty or trial, that there could never be a civil action, an underlying civil action at the same time on the theories that as articulated in this case. And that seems like a very broad rule.
Well, Your Honor, if her new claims were not contradicting her convictions, then she could bring it forth. For example, she has 2 other convictions, but those are not being conflicted with, are not in conflict with her new allegations. It is only that one conviction for aggravated fleeing that is in conflict at the moment. So if her new allegations did not conflict with any of her conviction, then she could move forward with her Section 1983 claim. But at the current moment, they are conflicting. And further, even if we take the facts in the light most favorable to petitioner, the conviction is still valid. And barring her claim under the Heck Doctrine is not about punishment. It's about procedure.
Is this case really about whether there was a conviction or not? Or is it really based on the type of conviction that occurred? Let's say is there a difference between a conviction by a jury of that crime and her no contender plea?
Well, Your Honor, if she had gone to trial and she would have resulted and she had been convicted, she would still have a conviction. And the only difference with a no contest plea is that she's not stipulating to the facts or admitting guilt, but it is similar in the fact that it's still a conviction and it's a valid conviction.
There are 2 minutes remaining.
Aren't you overlooking the basis for a no contest plea and why those are favored in the law?
Well, Your Honor, under the Heck Doctrine specifically, the type of plea entered is not relevant. It is only the conviction itself and the new claims and whether or not those new claims are contradictory. And the purpose of the Heck Doctrine was to ensure that judgments were final and consistent. And this court has always been disinclined to allow opportunities for collateral attacks on criminal convictions. And petitioner has the proper channels to go back to the trial court and attempt to vacate her conviction or get some sort of post-conviction relief as required by the Heck Doctrine before proceeding. But she has not done that yet. And respondents are not asking for this court to take away petitioner's day in court, but she is attempting to abuse the system by bringing in her new claims when she has not used those proper channels. In granting petitioner's request and allowing a Section 1983 claim to go forward would give rise to the possibility that there will be 2 judicial decisions that could reach diametrically opposed results regarding the exact same case, the same individual, and the exact same conviction. It would allow other convicted criminals to file similar requests, increasing the number of court decisions that would contradict each other and allowing more collateral attacks on criminal convictions. And that would severely undermine the finality intended in court judgments. Respondents respectfully request that this court affirm summary judgment and find that the Section 1983 claim cannot go forward because it is currently barred under the Heck Doctrine, since her new allegations imply that her criminal conviction is invalidated without first following the proper procedure that this court has established and that other citizens respect and follow.
Does the fact that there is the no contest plea, doesn't that necessarily mean that we don't know whether there's a genuine issue of material fact here that a jury should resolve?
The time reserved has expired.
We're looking at the application of the Heck Doctrine strictly from a legal point of view. But isn't this really concerned with factual dispute? And if that's the case, then doesn't it matter that we have a no contest plea here, because we really don't know what the underlying facts are as to the aggravated assault, the fleeing, the role the police officers played. All of that is up in the air.
Your Honor, I see that my time is up. Can I briefly answer your question?
Sure.
Your Honor, the Heck Doctrine and this court in the Heck Doctrine established that if there was an issue with the conviction or with the facts of the case, as petitioner currently implies, there is an avenue for her to attempt to fix that. And that is to go back to the criminal court and attempt to either relitigate her case or get one of the courts to declare her conviction invalid before proceeding. She can also alternatively change her current allegations so that they don't conflict with the 1983 claim that she's bringing forth and with her current convictions. But the fact here that really matters is that the new allegations imply that a conviction has been invalidated without first being overturned or declared invalid by a state court.
Do my colleagues have any additional questions?
Thank you.
Okay. Thank you, Counselor. Let's see. I think that you'll have Ms. Deaver. Who's going to argue next?
I am, Your Honor.
And you have 2 minutes. Is that correct?
Yes, Your Honor.
Okay. You may proceed.
May it please the court, 3 points on rebuttal. First, respondent stated that under Your Honor's hypothetical, if some stop occurs, then that in effect is a seizure. As the record reflects on page 2, when 2 rounds struck Ms. Flores, she crashed her vehicle, got out, and laid down. Ms. Flores was seized in this moment under petitioner and respondent's definition. And in Broward, the individual was seized because they died upon impact. This court did not address what happens if the individual had continued to drive past the barrier. But respondents contend that egregious actions by officers, so long as they fall outside of a results-oriented test applied inconsistently among lower courts, should not be actionable. Second, willfully and carelessly relents pertains to the act of driving in a manner that endangered the life of another person, not the knowledge or awareness of police officers' presence. None of the necessary facts for Ms. Flores negate any element of her underlying criminal conviction and officer immunity should not be expanded to shut the courtroom doors for a violation of Ms. Flores' person. Just because she committed a crime does not mean she consented to being shot in the back when she was no longer a threat. And third, respondent stated that the record demonstrated that Ms. Flores kept moving continuously, but I urge this court to read page 2. Ms. Flores crashed, exited her vehicle, and laid down to submit. Respondents also stated that the record is unclear if officers announced themselves and that there is a factual dispute as to when the bullets hit Ms. Flores after the commission of the crime.
There are 30 seconds remaining.
This court need not agree with one version or the other of the issue. It only needs to conclude there is a genuine issue of material fact, and this is enough to reverse and remand for further factual development. And it is for these reasons that we respectfully request that this court reverse the 12th Circuit Court of Appeals judgment. Thank you.
Okay. The bailiff, do we have any other arguments left? That's it, right?
Those are all the arguments, Your Honor.
Well, we've heard the arguments of the parties, and we thank you for your arguments. The case is now submitted, and this court's now in recess. So I guess we get offline, correct?
I think we were going to give comments
yes.
at this point, Chief Justice.
Okay, so now we'd like to make some comments on the arguments, and we're going to take some time to do that. But we do thank you for the arguments that have been made. Justice McKeague, you want to go first?
Oh, sure. Well, first of all, I just want to say what a pleasure it is to see 4 strong advocates of color. We need you in the legal community. I have moments of great pride in listening to all 4 of you this morning. So keep up the outstanding work. And then let me see. Ms. Deaver, you have great strength in your argument. I like the fact that you have a very good speed, a very good tone. Also, I think that it's brave to take on the rebuttal, especially when you're getting hit with all sorts of questions from individuals that you don't necessarily know where that's all gonna come from. You're very responsive to the questions that the court posed, so very impressed with that. Mr. Torres, I love the fact that you cite to the record, as that's extremely helpful to the court when we're listening to the argument. If we want to go and look at something later, that tells me that you know the record extremely well. And you also have a very good sort of the speed to your comments, very responsive, very respectful. So great job. Ms. Martinez, I love your confidence. I think that you've got great confidence in your presentation, and that to me is a great strength. You also cited the record. You also didn't sway at all when we were throwing lots of questions from you, coming at you from all angles. You sort of maintained, and not only maintained, but brought in additional points to support the argument that you were making. So also a great job. I love the ship analogy. I thought that was really, really nice. And then Miss, is it Ordimas, or how do I, Ordonez? I'm not saying your name very well. Also, you also did a great job, and I love the fact that you were able to sort of wrap everything up at the end. You guys all did a great job with time, because sometimes lawyers are not so great at that issue. And the fact that the question was posed, you knew you were out of time, and you still said, may I answer the question, rather than just jumping in and answering the question. You also were not swayed. We didn't sort of get you off task by, again, coming at you from all angles. So overall, you guys were all excellent. Really good job.
I go next, Steve. All right. I share the sentiment that you all are superb advocates. I've been on an appellate bench about 20 years and have judged my share of moot courts, and always amazed and pleased and proud at the quality of the advocates. So I share that sentiment, and I'll just start with Ms. Ordonez. I thought your closing was very strong also, and you fielded the questions well. I think for everybody a little more focus on the cases. After all, appellate courts are bound by precedent, and they're bound to, we have to distinguish cases. And I think all of you brought up the key cases in your arguments. And if I were going to say anything, maybe spend a little more time on those, because your judges have to deal with those. We do with Havens and with Brooks and all of those cases. We have to deal with them, but your knowledge of the record was fantastic. Mr. Torres, I think you did a wonderful job as well, arguing the Heck Doctrine. It's harder to follow for me than the first issue. And I've been resolving only civil cases for the last 12 years. I had some criminal cases on my docket when I was on the Court of Appeals. So you really did a great job of laying that out for the court. It's an interesting question. I thought you did a really good job. And then I'll move to Ms. Martinez. I think I interrupted you 10 times, and you did a fantastic job of staying on task. And that was more intentional, just because I think it gives you an opportunity to experience what appellate courts are sometimes like. There's 9 of us, and an advocate hardly gets a chance to finish a question before someone else chimes in. You did a fantastic job with that. And again, just great engagement with the theory, the cases, distinguishing the facts here. I thought that was wonderful. And Ms. Deaver, a fantastic advocate as well. And I think closing strong as you did is a really I guess important quality. A lot of times at the end of an argument, a litigant can't sum it up that way, and they close, but you just came in with your elevator pitch, what this case was exactly about. So that was fantastic. But overall, all of you are just tremendous advocates, and I hope that when you watch the video, that with your families and your friends, that you'll just see what we saw. Thank you, Chief Justice.
Okay. I didn't know this was on video. I probably would have combed my hair or something had I been aware. I've done this a number of times before for the HNBA, and I've been a long time member of the HNBA. And I'm always pleased to participate in this exercise. And every year it seems like the litigants are getting stronger and stronger and better. And you guys have advanced that particular ideal very, very well. Everybody had good composure. Usually there's one or two that you kind of want to comment about how they've held themselves and how they stand and everything. But all of you did a really good job at that. And we've all had to learn how to make these arguments and how to even sit as a judge in this virtual world. And you all adopted to this, exceptionally well. And I congratulate you on that. And I congratulate you on making it this far. And I can see why both of these teams have made it this far. That's something that to be commendable, and all of you should feel a sense of achievement, because that's what this is. The fact that you're sitting here arguing before real judges, answering the questions that the judges would raise in a court of law, I think is achievement for you, and you should honor that distinction. On a couple of comments on the substantive aspects of this, you always remember that an appellate court is applying a standard of review. We don't decide the facts. We're not here to decide the facts of the case. We can't. The facts are not before us. So sometimes when we get you involved in these questions about who drove away, how fast, and you're arguing the facts against us, then I think you start moving away from the basis of the appeal. The the appeal here, remember, what is it? It's summary judgment. That's what we're looking at. And in this case, it's not summary judgment. And I asked the question to see if, if you pick up on this, it's not a question as to a genuine issue of material fact. This is whether as a matter of law, and that's what the lower court decided on as a matter of law. And that's what you have to argue back to us. And so keep in mind that when you're before an appellate court, understand what the standard of review is. Even tell the judges that, Your Honors, today you're here to decide the following. And then tell us what the standard of review is, and then tell us how we're supposed to review that. What is the standard of review? Is it as a matter of law? Is it substantial evidence? What is it that we're looking here? And then wrap your argument around that. Once you know what the standard of review is, then you get your argument and you wrap it around that and keep reminding us that this is why I win. Because under your standard of review, Judge, this is the only outcome. So keep that in mind. Use cases. The argument at the appellate level is about a case that was heard last week versus one that was heard 2 years ago versus one that was heard, we have cases cited before my court that are like 1805 and talking about the founding fathers and all this stuff and everything, and you have that all the way from 1890, from the beginning of the founding of the country, maybe even English common law, all the way up until today. And what we have to hear are cases. Your skill and your articulation of the law has got to be on the basis of precedent, because that's the basis of our common law system, right? Precedent. Now, you argue that by analogy, you argue that by going back to the record and things like that. Like I did like the analogy that Counselor Martinez made with respect to a ship. And I happen, probably because I like ships and I like things that are nautical and everything, but there, that was a really good point. You got, in the old days, you issued up to somebody letters of marque to go out and capture a prize and to seize the goods, to seize the people. When does that happen? Well, it never happens. You don't get the prize until you actually, got them. So you actually have boarded the ship and rendered it powerless. But as long as Ms. Flores is still running, and as long as that ship is still going, well, that was a really good analogy. So you want to analogize your arguments to the court and maybe even give a hypothetical. But when somebody poses a hypothetical to you, like Justice Guzman did, you want to jump in there and answer that hypothetical. And when you hear one judge following up the same line of question, like do you remember when I said, about Justice Guzman talking about the Terry case, and then I went on, well, that should tell you that two of the judges here, I better zoom in on Terry and really address that issue. And then finally, this thing about closing strong and everything, this was one of the best rebuttals I think I've heard. That was closing strong for that particular team. And when you do go back and look at the video, look at there was strength in delivery, there was conviction and passion. Now, people say, somos Latinos and let's be careful with the passion here, but no, you want to show not passion by, yelling and carrying on, but you want to show passion by the strength of your argument and by your delivery. You want to bring that across. You want to win. You're not here to just, get up there and talk to us. You're here to win. You got to give it all you got. So when you're about to close out your argument, whether you go first, second, or third, you want to kind of come back and close with either your strongest point, or do you want to close by responding to another judge's questions? Like you're about to close, and then you may say, like, finally in closing, I want to say, Justice Reyna, you mentioned blah, blah. And you close directly on me because you discern I'm your big problem. So litigant and litigating is about all those things. It's about the cues that are going on in the courtroom and the answers that others are giving. It's how you're holding force and how you're managing the things that are about you. But above all, and this is what I picked up here, is that you have to master the law. And that means the legal case, the precedents, but also the record. And my sense was today that all four of you mastered the law. And I highly, highly appreciate that. That's the end of my comments. So somebody guide us.
Thank you, Chief Justice Reyna.
Somebody's telling them all the time what to do. So where do we go now?
I'll take it from here. Good afternoon, everybody. I'm Judge Betty Capote Urban. I am the director of the Moot Court competition. And this officially concludes the final round of the 26th annual Uvaldo Herrera Moot Court competition. I want to thank our elite panel of justices. It was an honor and a pleasure to watch you today and to have you judge our competitors. And I want to thank everybody who's watching for supporting the HMBA and the Moot Court competition. At this time, we are going to proceed to have the judges score, and we're going to ask everybody to leave the live stream, and the judges will continue to score at this point. Thank you very much. We will see you at the awards ceremony today at 4 o'clock. You can find the link on the HMBA main page. If you click on the Moot Court tab, you will see the link to the final award ceremony there. And we hope to see everybody this afternoon, 4 p.m. Eastern.